Okay, great. I think we'll get started. Hi, everyone. Thanks so much for joining today. My name is Delphine Rodrik, and I'm a legal advisor and Birth of Justice Fellow with ECCHR's Border Justice Team, which focuses on accountability for pushbacks and human rights violations at European borders. Today, we have a great set of speakers to discuss how these pushbacks impact children, in particular on the Balkan route, who are forced to travel through countries such as Bosnia, Croatia, and Slovenia for lack of access to legal pathways to protection in Europe. So first, we have with us Tatjana Ristic, who is an advocacy specialist for the Balkans Migration and Displacement Hub, an initiative of Save the Children's Northwest Balkans office. She will be speaking on the protection environment for children in Bosnia and Herzegovina, to where many children who try to enter Europe are pushed back and then find themselves trapped. From Croatia, we have with us Gordan Bosanac, the secretary to the Green Left parliamentary group in the Croatian parliament. He will discuss pushbacks there in the context of the current climate in Croatia. And from Slovenia, we have Miha Nabergoj, an advisor analyst at the Slovenian Center for Human Rights under the Human Rights Ombudsman, to speak about the pushbacks of children from Slovenia and how this practice has changed in recent months. And then to start us off, we have Aoife Nolan, professor of international human rights law at the University of Nottingham and a lead of the Advancing Child Rights Strategic Litigation Project, who will talk about the overall project giving rise to the panel. So each speaker will have around 5 minutes of presentation, one after the other, and after this, the floor will be opened for question and answer. So we'll be taking questions throughout the presentations in written format in the chat. So feel free to just write your question in the chat at any point during the presentations, and then we can pose them after the speakers' presentations. But once the floor is open, feel free to raise your hand using the hand raising tool to just ask questions directly as well. We will call on you. But yes, please keep yourself muted when you're not posing the questions directly. And just a note that the panel is being recorded as well. So before I pass over to the speakers, I'll just give a brief overview of the case of UF, whose experience is, of course, individually unique, but more largely reflective of the pushback practice that's the basis of this panel. UF is a young Rohingya asylum seeker who recently filed complaints against Croatia and Slovenia for pushbacks that he experienced in both states while trying to access protection in Europe. So, like thousands of other children, UF left his country on his own, and due to a lack of legal pathways towards protection and his continued insecurity, he was forced to make his way through several countries, also on his own, before ending up at the Bosnian border with Croatia in the late spring of 2021. And in Bosnia, he also found a lack of state protection and therefore proceeded on to Croatia. However, UF would be pushed back from Croatia to Bosnia at least 5 times without any sort of identification procedure, without the ability to claim asylum, and usually with great violence and intimidation, such as beatings by masked men, the destruction and burning of his personal possessions, and detention in overcrowded conditions. One of these pushbacks was also a chain pushback from Slovenia, in which Slovenian authorities apprehended him near the Italian border, ignored his statement that he was a child, and then handed him over directly to Croatian authorities, who then proceeded to push him back to Bosnia again. So, as mentioned, his experiences are, of course, reflective of the larger practice of pushbacks across these states and Europe more broadly. And his efforts are one of many to challenge pushback practices across the continent. But at the same time, they're unique in UF's determination to demand answers for these experiences through the complaints that he has filed. This has been done with the support of ECCHR, his partner lawyer, the organization Blind Spots, and the Advancing Child Rights Strategic Litigation Project. So these complaints are now before the UN's Committee on the Rights of the Child, which oversees Slovenia and Croatia's compliance with their obligations under the UN Convention on the Rights of the Child, and which can accordingly evaluate the impact of these pushbacks on UFCRC rights, including what both states must do to remedy the situation. And so in particular, his claims relate to provisions outlining the best interest of the child, ensuring special protection and assistance for children who are deprived of their family environment, the prohibition of torture and other cruel, inhumane, and degrading treatment, and protection of the child's right to identity, which includes recognition of their age. So the conditions and events that UF's case addresses took place between 2020 and 2021. So this is still relatively recently. Unfortunately, we're still seeing widespread pushbacks across Europe. But to better understand the conditions on the Balkan route now, how things have changed, what has remained the same, we'll move on to discussing the several current gaps facing access of children on the move to their rights in Europe. So now I will pass on to Aoife Nolan, who has extensive child rights experience in the context of the international legal framework, and she will briefly describe the Advancing Child Rights Strategic Litigation Project, which has supported this case and this project.
Absolutely. Well, thank you so much, Delphine. I mean, it's such an important case, and I think it's such an important issue that it's wonderful to have the opportunity to speak today. And of course, ECCHR is one of the partners in the Advancing Child Rights Strategic Litigation Project. And this litigation is so fundamentally important in terms of advancing the rights of children of UF, but also children in a similar situation. So all I'm going to do is very briefly describe the project, maybe give a bit of background, and to make clear how this case ties in with a broader move towards using law and litigation to advance the protection of children's rights, particularly the rights of children in especially vulnerable situations such as UF. So as a project, we're a 7-partner project. Some of us are from academia, some of us are from advocacy. We're based in Africa, Europe, Asia, and work together in order to advance understanding and thinking and practice around child rights strategic litigation. So what we mean by child rights strategic litigation is litigation that seeks to bring about positive legal and or social change in terms of children's enjoyment of their rights. And the reason we're looking at this issue as a project is because we've seen in the last, in fact, 3 decades since the adoption of the UN Convention on the Rights of the Child, a huge increase globally in child rights strategic litigation, a huge increase in these efforts to use the law to advance children's rights. And we've seen an expansion in terms of the places where that work is being done. We've seen an expansion in terms of the themes that are being litigated, the issues that are being litigated. And we've seen a significant expansion in the kind of people doing this work, right? So we're not just seeing pro bono ad hoc lawyers, we're seeing human rights institutions, we're seeing public defenders in different parts of the world, we're seeing academic clinics, a whole range of different people doing this work. And so the project is very much about looking at the work that's being done and thinking about how we can provide support to people doing this work as we move forward. And I think it's very important to explain why it is that the project, and indeed people doing this work, are focusing in on approaching the courts, on approaching bodies like the UN treaty bodies, the UN Committee of the Rights of the Child. And I think it's because there's a growing recognition of the exclusion of children from processes, from democracy, from the law and policy making activities or decision-making processes that have important implications for protecting their rights. And so people are turning to the courts as a way of getting children's rights onto the agenda and children's views onto the agenda. And this is particularly important when you're dealing with children like UF, who are likely to be on the receiving end rather than positively protected by law and policy makers in different countries. And certainly that's been his experience. So I would say that child rights strategic litigation is particularly important to children who find themselves at the hard end of law and policy making at the national level. And what do we try to do? Well, first of all, it's all about trying to strengthen the capacity of child rights strategic litigation to deliver on children's rights, okay? And part of it is about trying to harness academic knowledge to support the amazing work that people like ECCHR are doing in this area. It's about bringing a number of key cases before courts and quasi-judicial bodies, and UF, of course, is an example of one of those cases. But it's also about working not just about the challenges presented by child rights strategic litigation for children, but to work with children around this issue, to see how, children's views and thoughts about how child rights strategic litigation practice can be improved on. And we've a range of different activities. If you go to our website, it'll be very clear. We have a database of child rights strategic litigation cases. We have a network which people are welcome to join, where we've developed a community of practice around child rights strategic litigation. We've worked very hard about thinking about how litigators can make their own practice consistent with child rights. And we have very importantly sought to develop and to support child rights strategic litigation efforts in a number of thematic areas, particularly migration, such as the UF case, but also more recently in climate justice and children in the context of children who've been deprived of their liberty. But so I just want to leave it there, but just to say how important this case is, not just in terms of the project's activities, but also in terms more globally. When we look at the development of child rights strategic litigation, we're seeing more and more being brought in relation to the rights of children on the move. And UF is a fundamentally important case in the way in which it's bringing this issue of violent pushbacks to the attention of an expert body in a way that raises public attention around the issue, but also hopefully will resolve in an excellent outcome for UF, but also for children in a similar situation. Thank you.
Thank you so much, Aoife. I will pass on now to Tatjana Ristic from Save the Children, who will discuss the treatment of children on the move on the Croatian Bosnian border, particularly in light of the findings of a recent report of the organization called Wherever We Go, Someone Does Us Harm, Violence Against Refugee and Migrant Children Arriving in Europe Through the Balkans. This is really a wide-ranging documentation of the risk faced by children on the move, including through pushbacks in this region.
Thank you. Thank you for inviting us to this panel. It is always difficult to hear about the cases of children who experience violence at the Balkan route, such as the case of the UF. We have been working in the Balkans since 2015, and we have witnessed, together with other organizations working in providing support to refugee and migrant children and families, witnessed an increase in pushback practices and the overall the strengthening of the restrictive policies. And it seems that violence at the borders is a daily occurrence for refugee and migrant children who travel the Balkan route. And this has been confirmed by the findings of our latest report that you have mentioned. We launched it in September this year. It is based on the research that we conducted together with the University of Sarajevo and the Faculty of Political Science in Belgrade. And it's an in-depth qualitative study. We talked to 48 children who were at the time accommodated in the centers in Bosnia and Herzegovina, coming from countries in South and West Asia. And according to children accounts, what children told us is that they face all types of violence at all stages of their journey. So they are basically always at risk. And according to children reports, police officers and smugglers who they rely on to cross the borders are the main perpetrators of violence. So in children's experiences, police officers and smugglers are almost the same, which should not be the case. As the children who we interviewed that stayed at the time in Bosnia and Herzegovina, most of them talked about violence at the Croatian border. half of the children we interviewed in Umasana canton, and those children, so it's just next to the Croatian border. Those children talked about trying to cross Croatian border at least on average 3 times, and some of the children tried to cross 9, 10, 11 times and being pushed back every time. And the police violence at the Croatian border, but also other borders along the route, was described by children as excessive, brutal, and degrading. Children told us about being stripped naked, police officers taking away their belongings, insulting them, beating them, sometimes even using electric sticks. So children, all children who we talked to reported experiencing, witnessing, or hearing about police violence at the borders. And when they return to the countries of transit, Bosnia and Herzegovina or Serbia, for example, they do have an access, most of the cases do have access to basic services, such as shelter and basic protection services. But since the systems of support in the transit countries, including Bosnia and Herzegovina, is not strong and developed enough, there are still many gaps, and children very often fall through these gaps. And what also happens is that they do not report violence. They do not report violence for various reasons. One of the reasons is that there's a lack of reporting mechanisms. They don't really have anywhere to go to. They tell us that even if they do report violence, sometimes non-governmental organizations, they come and just write something, but nothing happens after that. It's also that children lack trust in authorities, which is understandable, having in mind that the main perpetrators of violence are police officers, who should be the ones who provide them protection and support. Children also want to continue the journey. They don't really want to stay in, most often they don't want to stay in the countries of transit, such as Bosnia and Herzegovina. They don't really see their future there. So reporting violence would just keep them here in these countries where they don't want to stay. So yeah, back to the research, we do have many recommendations connected to how to improve the situation for children in the Balkans, but also refugee migrant children arriving in Europe. But it is visible that the restrictive policies and including practices of pushbacks and violent pushbacks, they violate children's rights. And this is recognized also by children. One of the boys who we talked to said that police beat migrants so hard that they inspire such fear that people never even consider going there ever again. So the police violence, the restrictive policies, they what they do, they contribute to the violence, to the perpetuation and normalization of violence in children's lives. They push children back to the hands of smugglers who also abuse them, who are abusers, and they add on to the vulnerability of children to further violence. So these practices, violent practices at the borders, need to stop. We need to have better protection mechanisms for children at the borders. Children need to have access to protection and access to asylum instead of being pushed back. And in order for this to happen, there are many legal instruments that we need to implement at the borders. But there are also other things that we need to do to ensure that refugee and migrant children are protected and that they have access to rights. So this is the countries in the Balkans, which are now mainly transit countries. They need to continue to strengthen their protection system and asylum systems, and in order to do so, they they need to work with the European Union and the member states. So to ensure that there are durable solutions for children in these countries, but also there's need for legal pathways, and the European Union and member states need to work to introduce legal pathways for children and families arriving in Europe, so they can continue their journey if they want to, in a safe and orderly manner, instead of having to rely on smugglers and travel in this dangerous way. I will stop there. I'll be glad to answer any questions.
Great, thank you so much, Tatjana. And as mentioned before, to anyone who just recently joined, feel free to write questions in the chats, and we can pose them after. But also after the presentations of the speakers are completed, we'll open up the floor for people to to ask questions directly. So now I will pass over to Gordan Bosanac, who, in addition to his current position with the Green Left parliamentary group in the Croatian parliament, has a long history of migration work with Croatian civil society. He will focus on the current situation in Croatia, particularly in light of the expected accession to the Schengen zone at the beginning of next year. So thank you, Gordan.
Thank you, and hi to everyone. Although I do have a strong experience working as an NGO activist on the issue of the migration, today I will speak more politically, because today I am in politics, and we'll talk about the perspective as we are seeing on this issue from a Green Left group in the Croatian parliament. I would say one of the maybe most vocal political group in the Croatian parliament regarding the pushbacks and other mistreatments of people on the move on the borders. So the context, as we are seeing at the moment in Croatia, that the pushbacks are still happening, and they are not as violent as they were before, although there are some reports saying that the violence is still present, but we still, at least we see less violence, and what we are seeing, much more illegal migrants on the streets of city of Zagreb, but also other cities in Croatia. So this is at least one signal saying that something had happened on the border, that the border is not as close as it was, for example, 6 months ago, when there has been much more violation and violence on the border. So we are aware that the pushbacks are still happening, but we also see the change. And we have interpretation of this change due to the fact that Croatia is expected to join the Schengen on 1st of January 2023. And the criticism that was coming from different NGOs, but also political groups in the European Parliament, asking the question of pushbacks and violence on the Croatian borders. So on one hand, I think that official politics went into the direction, okay, we will let more people enter Croatia. We will not stop with pushbacks, but we will see that kind of the change. And the problem which we are seeing, according to the children on the move, is that current political perspective of the Ministry of Interior is that illegal migrant is illegal migrant, regarding any other identity. So is it a child? Is it a pregnant woman? Is it a gay person? It doesn't matter. It's illegal person, and everyone is treated equally, so to say, without discrimination. This is now parody I'm talking about. And this is the problem, that actually the Ministry of Interior is not recognizing particular vulnerable groups, which should have more rights, even they are illegal and crossing the territory of Croatia. So having in mind that Croatia wants to join the Schengen on January 1st, there has been pressure regarding the human rights behavior on the border. And the policy, as I said, we think that the ministry has been more soft on the border. And maybe we've been following the latest discussion in the European Parliament when Croatia got the green light from the Parliament, with 2 amendments put with many groups in the Parliament, saying that Croatia will have to be under the monitor even once we enter the Schengen. So it's not carte blanche that will be in Schengen. We will have to report also to the Parliament and the Commission what is happening on the border. But on the other hand, on Friday, there was a statement by the Austrian Minister of Interior, complaining and questioning the fact that should Croatia join the Schengen now, because they think that at the moment there are too many illegal migrants in Austria. They were talking about the number of 90,000 people. Out of them, 75,000 were never documented anywhere before. So you have this also political pressure on the Croatia that, you know, you should close the border. You should be more, I mean, this is how we are reading these messages. You should be more tough on the border. And I think that our Ministry of Interior and the government is not handling well this situation of actually two demands very visible in the European politics. One is please respect human rights. And the second is please don't let everyone to enter the European Union. And in that being squeezed between these two expectations from Croatia, I think that actually Ministry of Interior didn't treat it well, didn't find a good way and solution how actually the border can be protected without pushbacks, without violence at least, and also we think that they have much more opportunity to be open and understand that, you know, people who are coming and moving across the borders have different identities and different needs. In that sense, we've been advocating for many years that, you know, actually that the police behavior can be significantly changed, and actually that the border can be protected in a way that you respect some basic human rights on the border. We will see what will happen after the 1st of January if we enter Schengen, and we will know on 8th of December there will be vote in the European Council. But our expectation is actually that the border will be closed again. The border will be closed again, and we are afraid that maybe the violence will appear again. So this is what we want really to avoid as a political group. I hear some other voices in the comment. Okay, now it's good. And one last thing I would like to say, it's quite a big difference how the children are treated if they are illegal migrants captured either in Zagreb or on the border. And the problem, it was mentioned before, that unfortunately many migrants, people on the move, doesn't have a good access to asylum. So even if they want to claim it, they will not be able, they will not have an opportunity to claim asylum. Once they enter the asylum system, the situation is a little bit better. And actually tomorrow in the parliament, we will discuss the new changes of law on asylum, which will actually give more rights. It will recognize much more the needs of the children who are in the asylum seeking process. So this is what we see as a the very different situation at the moment in Croatia. I will stop here and I'm open for your questions.
Great, thank you so much for your contribution. So finally, for now, I will turn over to Miha Nabergoj of the Slovenian Ombudsperson's Office, who has himself been involved in the examination of complaints concerning the pushbacks of minors from Slovenia, to talk about these instances and the current state of affairs there. Thank you, Miha.
Thank you. So first of all, just a brief introduction about the Human Rights Ombudsman of the Republic of Slovenia. This is a national human rights institution. So we're an independent governmental institution entrusted with protection of human rights. And we're primarily working on complaints lodged by individuals claiming some human rights infringements by public authorities. But apart from working on these individual complaints, our institution is also doing more systemic work, research, and so on. So, in relation to the situation at borders, the rights of migrants, pushbacks on the Slovenian and Croatian border apparently started around June 2018. Since then, and until late last year, so until late 2021, this appears to have been widespread practice. So most migrants who were apprehended by the Slovenian police on the Croatian border or close to the Croatian border were treated in this improper manner. So not given the opportunity for an individual assessment. Apparently, their access to asylum procedure has been restricted, etc. Much like what has happened to the client in the ECCHR case in front of the UN Committee on the Rights of the Child. The Human Rights Ombudsman of Slovenia has been involved with this situation from the very early on, I would say, and has made a couple of reports and findings on the situation at borders. Also has performed work in the framework of its role as the national preventive mechanism. So this early work of the Ombudsman, so from the years 2018, 19, 20, has been summarized in a report that we've prepared last year. It has been published in July 2021. It's available in English. This was done in cooperation with ENRI, so the European Network of National Human Rights Institutions. So as stated, this is like a summary of our findings about pushbacks and other violations from that time. I can post a link in the chat later if someone's interested. So actually, from around last year on, we become even more active in this sphere, I would say, or maybe I can put it this way: our messaging became more clear in terms of the fact that violations are taking place on the Slovenian and Croatian border. Especially important was one recent case, individual case that we've worked on and prepared our final opinion in and shared it with the authorities, with the Slovenian Ministry of the Interior. This case concerned an Afghan minor who apparently was pushed back twice from Slovenia to Croatia. And the case is actually very similar to the UF case in front of the Committee on the Rights of the Child. So in this case, the Ombudsman found the violation of the right to asylum, prohibition of collective expulsion, prohibition of refoulement, the age of the person concerned was not taken into consideration, so he was treated as an adult, even though he claimed to have been a minor. And several other violations were also found by the Ombudsman, and this was very clearly communicated to the authorities. And also recently we've finished the investigation of another case of a Kurdish family who also suffered similar treatment by the Slovenian police. Now, in Slovenia, we have a new government since earlier this year, which is, and of course, the new Minister of the Interior. And it's quite a positive change because the current minister appears to be quite committed to respect of human rights of migrants and committed to the police conducting procedures at borders in a legal and humane way. So these findings in the individual cases by the Ombudsman were quite well received by the minister. She commented on them publicly and so on, and restated her commitment to conducting everything in a proper and legal manner in the future. Of course, as we have heard previously, things are changing in the region with the entrance of Croatia into Schengen. There are fears that more pushbacks and violence will continue. Also, with the new Italian government, it could happen that people will start being returned to this chain way from Italy to Slovenia again. And even though the pushbacks are not taking place on the Slovenian-Croatian border at the moment, and there's like this positive commitment by the authorities on this topic, we're still on alert for future developments to make sure that this kind of practice is not reinstated in the near future or anytime in the future, for that matter. So I will stop for now at this point.
Great. Thank you so much, Miha, and to all of our speakers for highlighting the respective contexts and how current conditions are. So we will now move into questions. So as I mentioned, feel free to put your hands up. We will call on you. I'll keep an eye out for this. During the presentations, we received 2 questions already. So I will start with those. The first question, I think maybe is best placed to Aoife at first, although anyone can jump in, of course. And it is, do you think that child rights strategic litigation can advance migrants' rights more broadly? Or are there risks in focusing on the rights of especially vulnerable migrants, namely undermining the general standards for those who are considered not vulnerable in comparison?
Okay, so I think that's a really good question. And I do think there's, if you look at, say, the way in which we're seeing strategic litigation being brought to advance the rights of children on the move, absolutely. It's not just all about, pushbacks for extreme cases. Some of them are around problems of perhaps more general application, or for instance, children who might not be facing physical violence in the day-to-day, but in fact have precarious migration statuses. So what I'm saying is it's not necessarily people in child rights strategic litigation isn't just being taken in the context of children who are, at immediate risk in the way that UF was. I do think, however, you don't see these cases being, while you do see cases around the particular situation, the situation of particular children being argued in terms of the vulnerability of those children, it's not a relative exercise. We haven't seen arguments saying, well, actually, this group of children are vulnerable and other groups of children aren't, so please protect this group of children. So it's not that, so in practice, you're not seeing a situation where a focus on the risk of especially vulnerable migrants is being used somehow to argue that they should be accorded protection when other groups aren't. So I think in practice, I think there's relatively low risk at the moment of the issue highlighted in the question.
Great, thanks. The other question that was posed is a bit on the role of Frontex, which we haven't discussed directly in this panel, but I wonder if maybe either Gordan or Tatjana would want to comment on the involvement, or more specifically the European Commission's recent proposal to extend its mandate more further to the Balkan region.
I haven't been following closely what is Frontex doing on Croatian border, so I don't know much about it. Maybe Tatjana can take over.
Well, yeah, there has been a lot of happenings in Frontex and developments in the recent period. So it remains I mean, we need to monitor the situation and see how the next developments will be. What we are saying, as we are currently, Save the Children, together with other colleagues, members of the Frontex Consultative Forum, we are saying is that Frontex needs to ensure in all their operations that human rights are respected, and that includes also better protection mechanisms within the agency, and also better monitoring mechanisms and the accountability mechanisms within the agency. And despite the presence of Frontex in the Balkans or at the borders of non-EU countries or the EU member countries, there is a need for additional independent monitoring mechanisms, which would be implemented in parallel with the Frontex presence. And these monitoring mechanisms at the borders need to be truly independent. I mean, there are recommendations. Our colleagues working in Brussels together with Amnesty, DRC, ECCHR, and other organizations were issuing press releases with recommendations related to independent implementation of independent border monitoring mechanisms, which were in line with what, for example, the national actors were doing in Croatia, for example, Center for Peace Studies. Saying that in order for the border monitoring mechanisms to be truly independent, they need to ensure that independent actors are involved. For example, ombudsperson, civil society organizations, they need to have access to all the areas at the borders. The areas where pushbacks occur, not only in the areas where there are no pushbacks. So they should not have any geographical or procedural limitations. Then they would need to have access to sufficient independent funds. They need to have access to data, particularly all data collected by the security forces, Ministry of the Interior, or whoever is in charge for the protection of borders. Then there's need for capacity building for the police officers at the borders. So training in human rights, children rights, child safeguarding, identification of potential victims of trafficking, etc. We need to ensure that those whose rights are violated can effectively actually report violence, and they can have access to justice, and the consequences need to be in place for the body that fails to cooperate with the mechanisms. And in general, there's need for accountability mechanisms for all individuals who have been proven to be perpetrators of violence or any illegal actions.
Thanks so much, Tatjana. maybe just while we're on the subject of monitoring, and then I will come right back to you, Vanya. I've seen your hand, but just because another question that's linked to monitoring, although in the more in the context of the Schengen accession, to Mr. Bosanac, is whether the Schengen accession of Croatia comes with the introduction of an effective monitoring mechanism, and whether that, if it does exist, would take into account the specific situation of children, and if this is not the case, why? Thank you.
Yes, this independent, so-called independent monitoring mechanism, which unfortunately is not as independent as it should be, and it was criticized not only by us in the parliament, but by many NGOs, was a mechanism which was for the first time introduced for Croatia. And Croatia is the first EU member state that is implementing this monitoring, independent monitoring mechanism on the border. And the point of this monitoring mechanism was to satisfy all those who are critical within the Europe on human rights violation on the Croatian border. So that was kind of attempt to send the message that, you know, Croatia is ready to do something with the human rights violation on the border. And it seems that, at least in the political arena, vast majority of members of European Parliament are satisfied with that because they voted in favor of Schengen, and they also all said that they think that this mechanism is functioning, and now this mechanism will be offered to other member states to be implemented. The Croatian government is saying that it will be obligatory to all member states. I'm not that optimistic, but I think it will be on voluntary basis that other member states can introduce this mechanism. But this mechanism has helped Croatia to improve the image of itself to join the Schengen. Is there something specific on the situation of the children? I think no. The mechanism, as far as I remember the agreement, but maybe Vanya, who will be talking after me, knows more. I think the mechanism is only saying very generally about human rights violation, human rights respect, and the rule of law respect. So again, the children are not recognized specially, but only under this umbrella of human rights in general. And why this is not the reason? You know, after I entered the politics, I learned one very important thing that, you know, when you push for something, you cannot expect everything immediately that will happen. But you really have to be patient and push little by little by little by little. So this mechanism which we are having now is a little step forward, which we can now build on it. And maybe it's interesting from the advocacy perspective of many of you who are dealing with this, if this mechanism will be introduced to the other states, really to integrate more on children's rights in that mechanism.
Thanks so much. Now on to you, Vanya. Thanks for your patience.
Thank you very much, and thank you for an interesting discussion. As regards Gordan Bosanac's question, I agree with him, and yes, there are no specific provisions as to the child considerations in any way. But I also have a question regarding UF case. I was wondering why the case was litigated before the UN Committee on the Rights of the Child rather than some other legal avenue, such as Strasbourg Court. Has there been any envisaged strategic advances to litigating it there? I suppose my question goes either to Ms. Rodrik or Ms. Nolan. Thank you.
Thanks for the question. I mean, there are sort of a number of considerations regarding why the case was brought before the Committee on the Rights of the Child. Some of them are more technical and administrative, concerning time limits and really just the sort of recent change in the period of time after which cases can be submitted to Strasbourg following the exhaustion of domestic remedies. From 6 months to 4 months, for instance, has been makes it even more difficult for people who have suffered pushback, specifically to bring those cases there, given the fact that people are pushed back into really vulnerable and unstable conditions, and as really highlighted by this panel, don't have access to legal support, much less really shelter and adequate conditions of reception. So I say that just to sort of highlight the generally or the general sort of obstacles to pursuing accountability for pushbacks generally, and how this usually takes a lot of time. But as for the Committee on the Rights of the Child in particular, of course, sort of the main reasoning here was that UF's pushbacks occurred while he was still a child, during the ages of 16 to 17. And so it's an opportunity for the committee, which, sort of oversees one of the most widely ratified international human rights instruments, to evaluate pushbacks through the Convention on the Rights of the Child in particular, and to sort of come at this or analyze how pushbacks impact these rights through different angles. This case also builds off, I would say, a previous case before the Committee on the Rights of the Child that concerned the pushback of a Malian minor from Spain to Morocco, and in which the committee found very clear violations of his treatment at this border. So it, in that sense, also represents an opportunity to really strengthen the articulation of these protections for children in particular. As mentioned by, for instance, Tatjana, the reporting of violence by children and against children is also quite, I would say, overlooked generally. So those are just some of the considerations. I won't take up more time. Does anyone else have a question that they would like to pose? We have about 5 more minutes. If not, I will pose one. Okay, I will pose a question then to Miha. So, I mean, so you mentioned that the current state, or this current shift in, or lack of pushbacks really that are happening currently between Slovenia and Croatia. And I wonder if that is also tied to the fact that these returns that are happening under the readmission agreement are operating differently, in that there is more access to procedural protections, that the identification of minors is happening as it should be, or is it that those returns, or that returns under the readmission agreement are just not necessarily being relied on the same way?
So apparently what changed about 1 year ago is actually concerns the practice of the Croatian police. So a change in their practice effectively resulted in termination of pushbacks from Slovenia to Croatia. So apparently what happened is that the Croatian police, when they were brought migrants by the Slovenian police for readmission, started asking these people whether they have expressed an intent for asylum to the Slovenian authorities. And if they replied affirmatively, they refused to accept them and return them to the Slovenian police. Something I think that probably should have been doing all along, because a big component of the pushbacks is that asylum, these expressions for intents for asylum were ignored by the Slovenian police. So eventually the Slovenian police stopped even trying to readmit people who told them they're seeking asylum, and started conducting procedures in a proper way. So starting this asylum procedure, transporting them to the asylum reception facility. There's an analogy perhaps that we can make with what's happening and might happen in the future on the Italian and Slovenian border. So that there are concerns that Italy in the future could start doing something like that, so returning migrants to Slovenia, even though they expressed to Italian authorities that they would like asylum in Italy. And of course, on other borders, such things are taking place as well, or might again take place in the future. So we could perhaps learn something from this, the way Croatian police started asking their colleagues from a neighboring country, or not them, but rather the migrants who are returned, whether they have expressed an intent for asylum. This seems to be a practice that sort of puts a stop to this practice, and then it can have repercussions on the next on the next border. So this could be an advocacy for practice like that. Could be important to stop chain refoulement, chain returns, chain pushbacks in the region.
Thanks very much. I have a final question that I could ask, but I also want to give anyone else the opportunity to ask one last question before we close. Okay, then I think this will be directed maybe first to Gordan. We started, obviously this panel is in the context of litigation generally against pushbacks. So I would be interested to hear your take on what the impact of existing litigation against pushbacks in Croatia has had, particularly the case MH v. Croatia, which concerned the death of a young girl following her pushback from Croatia. And then sort of wrapped up into that question, if anyone would like the final word, would just be what other, outside of litigation, what other sort of pressure points or strategies maybe that we've overlooked, or maybe that you're seeing from your unique respective positions coming at this issue from different ways exist. So to all four of you, anything that comes to mind.
Yes, of course, the positive outcomes of strategic litigation, but not only the positive, in general, strategic litigation have an impact, if not necessarily and immediately that they're changing the system. For sure, we are using it heavily in the parliament. So even in tomorrow's debate on the changes of law on asylum, we will for sure refer on the conclusions of the European Court of Human Rights on the AGM case against Croatia. So this is a powerful tool. Unfortunately, we are seeing that this judgment is not implementing as well as we would expect it. But politically speaking, we are using heavily the outcomes of the strategic litigation. So keep on going and doing it before any courts and bodies as much as you can. Yeah.
I'll go next. So talking about what works. Well, one of the reasons that we did the report that I talked about is to bring more focus on children arriving through the Balkan route, especially in the context of the Ukrainian crisis, and how the attention shifted, and we just did not want to forget, the children who the other refugees and migrants. I mean, all children have right to be protected in the same way, because they also have same rights. And yeah, what we did, we talked to children. We brought children's voices to the discussion. And the report did attract good attention. I mean, we did talk to a lot of media, and it really it helped us to bring this topic back to the attention of the audience. So I'd say that although it is an old strategy, asking people who are affected and bringing their experiences, their needs, their recommendations, everything, basically what happens to them, back into discussion, talking to them and putting them into the spotlight, which you're also doing with strategic litigation, is always the way to go. And yeah, also what works, although it becomes more and more difficult to talk about migrations and children in migration and to raise this issue. I think working coalitions, this is something that proves to have good results. So working with other partners, whether it's NGOs, agencies, independent institutions, or even the authorities. The authorities, of course, which are allies, and academic institutions. So to work with as many stakeholders as possible.
Thanks so much to you both for answering that question. Yeah, I really liked how the report that Tatjana is referring to has a particular section that has recommendations from the affected children themselves, which is quite powerful. And it's also nice, very interesting to hear how the litigation can also play a very important, or be a very important political tool. Miha or Aoife, would you have anything else to add?
Yeah, I think we'd say generally that one of the key findings of the project, which reflects work around strategic litigation more generally, is it's not necessarily just about the legal outcome. It's exactly as Tatjana has spoken about. It's about profile raising, getting it on the political agenda, and litigation serving as the basis of kind of extra legal advocacy, public education, communication. So I think that's a really vital part of it, that it's not just, when we look about the value of, say, child rights strategic litigation, it isn't simply about the judicial output. It's about the work that you can, and the energy and the momentum and the attention you can generate around the litigation process, regardless of the ultimate outcome, in fact.
Great, thanks so much. So I think if no one else has anything to add, we can close out the panel. Thanks so much to all of you for attending, and to all of our speakers for their very important insights, and also to the Advancing Child Rights Strategic Litigation Project. The panel, like we said, was recorded, so feel free to reach out to us for the recording. We will paste an email address into the chat. That has already been done. So you can contact Abby Darcy for further questions or for the recording itself. So thanks very much.
Thank you. Bye.
Thank you.
Everyone, bye.
Bye.